Hello, my dear students. Today, in labor law paper first, we'll talk about the retrenchment and the compensation to the workman for retrenchment. This topic we will cover under Industrial Disputes Act 1947, and this topic is given in unit number 4, and this is video lecture number 37, and in this lecture we will discuss this topic today. Retrenchment means the termination by the employer of the service of a workman for any reason whatsoever, otherwise than as a punishment inflicted by way of disciplinary action, but it does not include a voluntary retirement of the workman or retirement of the workman on reaching the age of superannuation if the contract of employment between the employer and the workman concerned contains a stipulation in that behalf. So retrenchment means the termination of the services of a workman by the employer, and whatsoever the reason is otherwise than as a punishment inflicted by way of disciplinary action, but it does not include voluntary retirement of the workman. It does not include the retirement of the workman on reaching the age of superannuation if the contract of employment between the employer and the workman concerned contains a stipulation in that behalf. This definition of retrenchment is given under section 200 of the Industrial Disputes Act. Then subclause BB, termination of service. So what are the other things which will not be included in the retrenchment? The termination of the service of the workman as a result of non-renewal of the contract of employment between the employer and the workman concerned on its expiry, or of such contract being terminated under a stipulation in that behalf contained therein. And clause C says that the termination of the service of a workman on the ground of continued ill health. So what is the meaning of retrenchment by this definition, my dear students? Retrenchment means the termination by the employer of the services of a workman for any reason whatsoever, otherwise than as a punishment inflicted by way of disciplinary action, but it does not include. So any termination of services by the employer to a workman otherwise than a punishment inflicted by way of disciplinary action, but does not include voluntary retirement of the workman on reaching the age of superannuation, if the contract of employment between the employer and workman concerned contains a stipulation in that behalf, and termination of the service of a workman as a result of non-renewal of the contract of employment between the employer and workman, and termination of the service of a workman on the ground of the continued ill health. My dear students, there is an important case related to this, that is Balbir Singh versus Kurukshetra Central Cooperative Bank Limited. And the court has observed that the intention of the parliament in enacting clause BB, which is related to the non-renewal of the contract in section 200 of the Industrial Disputes Act, was to exclude certain categories of workers from the term retrenchment, but garb of non-renewal of the contract even when the work subsists. And this clause as a whole has to be construed strictly in favor of workmen to ensure that the act is implemented in the letter and spirit. So this is an important case related to the retrenchment, Balbir Singh versus Kurukshetra Central Cooperative Bank Limited. So you just have a look of that case, you go through the case and try to comprehend this. Now we talk about the special provisions relating to the retrenchment gain under section 25 and conditions precedent to the retrenchment of a work. So my dear students, the condition precedents are for the retrenchment: no workman employed in any industrial establishment to which this chapter applies who has been in continuous service for not less than 1 year under an employer shall be retrenched by the employer until A, the workman has been given 3 months notice. So no workman employed in any industrial establishment to which this chapter applies who has been in continuous service for not less than 1 year under an employer shall be retrenched by that employer until the workman has been given 3 month notice in writing indicating the reasons for retrenchment and the period of notice has expired or the workman has been paid in lieu of such notice wages for the period of that notice. B, the prior permission of the appropriate government or such authority as may be specified by the government by notification in the official gazette has been obtained on an application made in this behalf. So prior permission from the appropriate government for or such authority as may be specified by the government by notification in the official gazette, and this permission has been obtained on an application made in this behalf. Number 2 is condition precedent is the an application for permission under subsection 1 shall be made by the employer in the prescribed manner. So what we have gone through under subsection 1 of this section, the main section we were studying, 25N, an application for permission under subsection 1 shall be made by the employer in prescribed manner, stating clearly the reasons for the intended retrenchment. And a copy of such application shall also be served simultaneously on the workman concerned in the prescribed manner. So, an application of the permission under subsection 1 shall be made by the employer in the prescribed manner and clearly stating the reasons of the intention or why this retrenchment is going on or why the employer wants to go for the retrenchment, and a copy of such application shall also be served simultaneously on the workman concerned in the prescribed manner. So this is subsection 2, and then where an application for permission under subsection 1 has been made, the appropriate government or the specified authority, after making such inquiry as it thinks fit and after giving a reasonable opportunity of being heard to the employer, the workman concerned and the person interested in such retrenchment may having regard to the genuineness and the adequacy of the reason stated by the employer. So we have to check whether whatever means the employer is mentioning in the application for the purpose of the retrenchment, whether this request or this request for the permission is having some genuineness or adequacy of the reasons stated by the employer, and the interest of the workman and all other relevant factors by order and for reasons to be recorded in writing. So when this application has been made, then whether the application has been rejected or an order has been given, all the reasons for the order or for the rejection has to be recorded in writing, and this grant or refuse to grant such permission and a copy of such order shall be communicated to the employer and the workman. So whether this application for permission is being rejected or refused, or this grant is being means the appropriate government is allowing to go for the retrenchment. So all the reasons has to be in, all the reasons have to be in writing, and a copy of such order shall be communicated to the employer and the workman as well. Where an application for permission has been made under subsection 1, under the appropriate government or the specified authority does not communicate the order granting or refusing to grant permission to the employer within a period of 60 days from the date on which such application is made, that the application, then the permission applied for shall be deemed to have been granted on the expiration of the said period of 60 days. So my dear students, in the subsection, once the application for permission has been made under subsection 1 and the appropriate government or the specified authority does not communicate the order of granting or refusing to grant the permission to the employer within a period of 60 days. And when, from which date we will count those 60 days? From the date on which such application was made. Then the permission applied for shall be deemed to have been granted on the expiration of the said period of 60 days. So within 60 days, appropriate government has to communicate whether the application has been granted or refused, or means if they are not doing so within a period of 60 days from the date of which the application was made, then permission applied shall be deemed to have been granted on the expiration of the said period of 60 days. And in subsection 5, an order of the appropriate government or the specified authority granting or refusing to grant permission shall subject to the provisions of subsection 6 and be final and binding on all parties. It would be final and binding on all parties concerned and shall remain in force for 1 year from the date of such order. And the appropriate government or the specified authority may, either on its own motion or on the application made by the employer or any workman, review its order granting or refusing to grant permission under subsection 3, or refer the matter as the case may be, cause it to be referred to a tribunal or adjudication, or provided that where a reference has been made to a tribunal under this subsection, and it shall pass an award within a period of 30 days from the date of such reference. So the appropriate government or the specified authority, either means on its own motion or on application made by the employer or on the workman, they can review the order of granting or refusing the grant permission under subsection 3. And where no application for permission under subsection 1 is made, or where the permission for any retrenchment has been refused, then such retrenchment shall be deemed to be illegal. So if the no application for permission under subsection 1 is made, and where the permission for any retrenchment has been refused, and such retrenchment shall be deemed to be illegal from the date on which the notice of the retrenchment was given to the workman, and the workman shall be entitled to all the benefits under any law for the time being in force, as if no notice had been given to him. And such exceptional circumstances as accident in the establishment or death of the employee or like this, it is necessary so to do by order directing the provisions of subsection 1 shall not apply. And this is what means in relation to such establishment for such period and is specified in the order. Then where permission of retrenchment has been granted under subsection 3, means the permission was granted under subsection 3, or where permission for retrenchment is deemed to be granted under subsection 4, every workman who is employed in the establishment immediately before the date of application of permission under this section shall be entitled to receive at the time of the retrenchment compensation which shall be equivalent to the 15 days average pay for every completed year of continuous service or any part thereof in excess of 6 months. So, and the infirmity in retrenchment by reference to section 25 and cannot be ventured to be found out without laying factual foundation attracting applicability of the provision. And it is incumbent on the management to prove that the copies of the application as required by section 25 and read with rule 76A of the Industrial Disputes Rule 1957 were served on the concerned workman. And now, my dear students, we talk about the compensation for retrenchment. While affecting retrenchment of the workman, it is obligatory on the part of the employer to pay retrenchment compensation to the workman at the rate of 15 days wages for every completed year of service to be calculated at the last gross salary of an employee. And so 15 days salary of the last gross salary for every completed year of service. And eligibility for the compensation is an employee is eligible for the retrenchment compensation when the following conditions are satisfied. A, the employee must be a workman. B, he must have in a year of continuous service for a certain number, that is 240 days worked in the previous 12 months, which is considered to be equal to a year for the purpose of the continuous service. So 240 days working would be treated as 1 year continuous service for the purpose of this retrenchment compensation. And continuous service here means that uninterrupted service, however, sickness, authorized leave, legal strikes, and lockouts, and work stoppages not due to a worker's fault do not interrupt one's service. Over the above, the 1 month's wages where notice is not given, the retrenched workman should be given 15 days average pay for completed year of continuous service or any part thereof in excess of 6 months. So, continuous services means uninterrupted service, and sickness, authorized leave, legal strikes, lockouts, and work stoppages not due to a worker's fault do not interrupt the service. And over the above, the 1 month's wages where notice is not given, the retrenched workman should be given 15 days average pay for completed year of continuous service or any part thereof in excess of 6 months. So if someone has worked, say, for example, 7 years and 7 months, then it would be treated as a 8 year, because the 7 months is in excess of 6 months, it would be treated as a 1 complete year. So in this case, we will calculate for retrenchment compensation for 8 years we will take into consideration. And for this purpose, average pay will be calculated as under. If the employee is entitled to monthly salary, then on the basis of the salary of the last 3 calendar months, we will take the average pay. If the the employee is being paid on monthly basis, monthly salary he is receiving, then on the basis of the salary of last 3 calendar months. And if the employee is entitled to weekly wages, then on the basis of the wages of last 4 completed weeks. If the wages is on the wages on the weekly wages, basis of the weekly wages, then the on the basis of wages of last 4 completed weeks, we will calculate the average pay. And if the employee is entitled to daily wages, then on the basis of the wages of last 12 full working days for the purpose of the average pay. And conditions to be fulfilled for the retrenchment: if the conditions or requirements given in these provisions are not followed by the employer, then the retrenchment of the employee will be treated as illegal and invalid. And according to this provision, a workman employed in an industry or who has been in continuous service for not less than 1 year under an employer cannot be retrenched unless The workman has been given 1 month notice in writing indicating the reasons for retrenchment, and the period of notice has expired, or the workman has been paid in lieu of such notice wages for the period of such notice. And the workman has been paid compensation at the time of the retrenchment. So these are the conditions we are talking about to be fulfilled for retrenchment. The workman has been paid for compensation at the time of the retrenchment, and notice in the prescribed manner is served on the appropriate government that going for the retrenchment. And hence, if aforesaid conditions are not fulfilled, then the employee before retrenching employee, then the employee can challenge the same. Thank you so much, my dear students, and I believe this lecture will help you, and I believe you will comprehend about the retrenchment and the uh, how do we go for the compensation for retrenchment, and what are the conditions for the uh, what are the conditions to be fulfilled for the retrenchment. So this is all what we discussed today for today's lecture, and I believe this lecture will definitely help you and will make you comprehend about the retrenchment and the retrenchment compensation to the workman. Thank you so much, my dear students. Have a nice time. Have a nice day. Thank you. Bye bye. Take care.